Page 7, Kristen Moore.
Christian Moore?
Yeah, Kristen Moore, I'm sorry. She's in North Broward. North Broward?
Hang on. I don't have any idea where page 7 is, you see.
On your docket? Oh, I see.
Yeah, because my docket and this doesn't match up, you know. I just have the rambling stack here. Kristen Moore, M-O-R-E?
Correct.
Okay. This municipal ordinance of violence, sleeping on the sidewalk, you want to plead it?
Yes, Judge, if I could.
Okay,
North Broward, Your Honor.
North Broward. Kristen Moore.
Can you put on a brief recall? She's on her way down.
Okay. Can I ask you real quickly also about Paula Rackle? Is she still in medical reset?
Yeah, she's still a reset.
Okay, no problem.
Okay, what else do you have?
Judge, we could do, how about Kevin Burns? He's in North Broward.
How far down is he?
He's on page 14, Judge. So half as far, twice as far as number 7.
Kevin Burns?
Yeah, B-Y-R-N-E.
What's your name, man?
Kevin, how are you feeling today?
I could be worse. How about yourself?
I could be worse as well, so we're tied.
Okay.
Mr. Burns, would you like to resolve both of these matters today?
What are the charges?
Judge, for Mr. Byrne, he has 2 municipal ordinances coming out of Pompano Beach, and they both are, one's a capias for panhandling, and the other one is failure to wear his...
Sir, do you want to plead no contest?
Yes, sir.
Okay, time served.
Thank you, Judge. He has actually 3 matters, Judge. I want to make sure that's on all 3 cases.
That's all. That's 3, actually,
3
no contest, all 3 cases.
Yeah.
Time served, waive.
Perfect. Thank you very much.
Thank you.
Take care, Kevin.
Judge Murphy?
I couldn't find the file. Let me know when you get to it again.
Okay.
I have Miss Moore here.
Okay.
Come on, Moore. Come on.
How are you, Miss Moore?
Ms. Moore, you're here. Your attorney's present. You've got a municipal ordinance violation, capias, of sleeping in the open. Do you want to plead no contest?
All right, you can go back inside.
Okay, time served, waive. Have a good day.
Thank you, Judge. Have a good day. And the other matters, I have one other, but you can go ahead and do that without. More than capable, I'm sure. Take care. Good to see you.
Thank you, Steve. I needed to vote of confidence. Okay, Shannon Tucker.
North Broward, Your Honor.
Sharon Tucker.
Yes, sir.
You're charged with domestic battery. I find probable cause. The court's going to set bond the amount of $500 and no contact with the alleged victim. If you have any weapons, you must surrender them. I mean, any firearms.
No, sir.
I spoke to Ms. Tucker this morning. I would ask if you would consider ROR in order pre-trial. The victim did sign an affidavit.
I'll put her on pretrial.
Thank you.
Okay.
Thank you, Judge.
Excuse me, ma'am. Standard. Norma Martinez. Everybody signed waivers of prosecution. Nobody gave a statement. Okay, Norma Martinez, you're charged with domestic battery. I find probable cause. Bond is set in the amount of $1,000. No contact with the alleged victim.
When it comes to Ms. Martinez, I'm unsure if she's going to be able to afford a monetary bond. I'm asking for a photo order. As we can see, she was hit as well. According to the PC, this was a mutual combatant situation. It seems that it started when her son was in some sort of dispute.
Counsel, this was a family battle. Okay, we've got 3.
It seems like the mother was coming to the aid of her son, though, and then there was some sort of...
No, what happened was something happened with her son. She hadn't seen it. She jumped in, assuming something, and the rest of it. All right, I'll set the bond at $500. That's it. No contact. Have a good day. On this, give me these in a stack when we're done. Huh? Yeah, because what'll happen is, if you don't, it's too much back and forth, slows us down. Okay. Tish Franzen.
Main jail, Judge.
Ms. Franzen, you're charged with domestic battery. I find probable cause, aggravated battery with a deadly weapon. I find no probable cause as to count 2. Yeah, take a look.
Did you talk to Miss Martinez on the phone?
According to this, there was a push, there was a shove, there was a...
Yeah, she's saying she doesn't understand.
And she got in her car and left. Do you have another affidavit or something? Counsel, you're talking to the table.
Oh, I apologize. It's the same date, Your Honor. It's just another probable cause.
Excuse me, could you keep it down so I could hear? All right, speak up, counsel.
Yes, Your Honor. That the defendant's in a vehicle, reverses the vehicle, stops, and then the victim. Do you not have the probable cause?
Where I'm looking. Did she what?
It's separate, Your Honor.
Well, that's the reason why I don't have it.
Judge.
Well, it's attached to it.
All right, maybe. Oh, wait a minute, it's on the other side. Got
Excuse
put
me,
by
Judge.
something. Okay. Okay. Court finds probable cause all counts. What say you state as to count 2 on the bond?
I would be asking, Your Honor, for both counts, Your Honor, for there to be a $2,500 bond as to each count. The defendant does have a 2017 domestic violence battery that was dropped, as well as from 2010.
Count 1, $1,000. Count 2, $1,500. No contact with the alleged victim. If she has any firearms, they must be surrendered. Okay. Rose Thompson.
No problem, Your Honor.
Rose Thompson, you're charged with aggravated battery with a deadly weapon and false imprisonment. Court finds probable cause on both counts, sets bond amount of $2,500 on count 1, $1,000 on 2. No contact with the alleged victim. And if you have any firearms, they must be surrendered to the local agency, police agency. Dominique Brown.
No problem.
I'm asking for a phone order for Ms. Thompson, just so she can get phone numbers off her phone.
A what, phone number order? Yes, granted. Okay, Dominique Brown.
No problem, Your Honor.
Dominique Brown, you're charged with domestic battery, disorderly conduct, and resisting an officer without violence. Find probable causes counts 1 and 3. Bonds are set in the amount of $1,000 and $500 respectively. What is the disorderly conduct? Appears to be part of the fight.
So because that was done in public, Your Honor, obviously that.
Who was the public?
Or where that location is, Your Honor, because of that fight, Your Honor,
Yeah, but who was the public?
this is where that address is.
Well, the state's hooking, Your Honor. I'm just going to ask for a photo order.
There needs to be some public that's disturbed. Court at this time sets bond count one, $1,000, count two. No probable cause is found. The defendant is ROR'd. On count three, $500. No contact. Surrender any firearms. Natasha McLaren.
Main jail, Judge.
Natasha McLaren, you're charged with aggravated assault with a deadly weapon, domestic violence. The court sets bond the amount of $2,000, find probable cause, no contact, and with the alleged victim. And if you have any firearms, they must be surrendered.
Judge, Ms. McLaren would ask for a $1,000 bond. That's something she can't afford, and she'll be living at a friend's house.
Hang on. Okay, this is where the alleged victim refused to cooperate also and give a statement. Court will, bond is $1,000, no contact. Excuse me, who's speaking? Yes, sir?
Yeah, I'm her husband. I'm supposedly the victim.
And what do you want?
I just wanted to say that when the officers came to the incident.
Okay, let me tell you something, sir. You don't want to be talking about the facts of the case, okay? Because everything that is said today is being taken down. While you're not charged with that, okay, and you may want to help your wife, you may end up saying something saying something in a way you wish you didn't. Or you may say something that is not good for you. So if you need to, my understanding is, so don't discuss the facts of the case. Anything else you want to tell me?
I just wanted to say that I was not given the opportunity to voice my side of the story.
To the police?
Correct.
Okay. All right, well, bond is set the amount of $1,000.
Okay, thank you.
Okay. Inmar Maldonado.
Judge, we need a Spanish interpreter, please.
Spanish interpreter coming right up.
Thank you, Judge.
Never had such good service. Swear to interpret from Spanish to English and English to Spanish as best possible.
I will introduce Angela Lopez, certified Spanish interpreter for the courthouse.
Thank you very much.
Thank you.
Okay, Mr. Donald, yeah. You're charged with assault, domestic violence. You're charged with battery, which domestic violence, and then you have capiouses for unlawful tag and operating without a valid driver's license.
Señor Maldonado, el señor juez habla en este momento. Lo acusan de intento de agresión física en violencia intrafamiliar. Es la primera acusación. La segunda acusación es de tocar o pegarle a alguien en violencia intrafamiliar. Las acusaciones 3 y 4 son de órdenes de captura por infracciones de tránsito o delitos penales de tránsito, de estar operando sin una licencia válida y de tener una calcomanía que no le correspondía en la placa.
Okay. Court at this time finds probable cause. The court sets bond in the amount of $500 on the assault and $1,000 on the domestic battery, on the bonds are $250 on each of the other capiouses, and
El señor juez habla de nuevo. Haya un motivo fundado para detenerlo y le impongo una fianza de $500 para la primera acusación, que es intento de agresión física en violencia intrafamiliar. Impongo $1,000 de fianza para la segunda acusación, agresión física en violencia intrafamiliar. Y las acusaciones 3 y 4, que son las órdenes de captura, tienen una fianza ya impuesta de $250 cada una.
So you have $2,000 in bonds.
Entonces el monto total de la fianza es de $2,000.
2,000. Y si los pago hoy,
¿Perdón?
entonces ya sale.
Perdón, señor. I'm sorry, Your Honor.
Si
Perdón.
pago ahora, salgo ahora.
If I pay that now,
If you post $2,000 bond, you'll be released.
Sí, señor, usted saldrá en libertad hoy.
Tony Bernhardt.
Thank you.
Barnhart. Yes, I did. I'm sorry.
Señor, no, que
No
no debe
contact.
tener, señor Maldonado, que no debe tener contacto o comunicación con la supuesta víctima. ¿Entiende, señor?
Very good. Thank you very much.
Thank you.
Tony Barnhart,
Yes, Judge.
you're charged with count 1, battery, domestic violence. You're charged with count 2, battery, domestic violence. Where's the second battery? Maybe, let me see. Oh, there's another, okay, there's an attached one. Okay. Court, on count 1, the court sets bond the amount of $1,500. On count 2, the court sets bond in the amount of $1,000. There'll be no contact. If the defendant has any firearms, they will be surrendered to the local police agency.
Judge, Mr. Barnhart is unable to afford the $250 to a surety. Is there any chance of getting a lower bond or pretrial for Mr. Barnhart?
I think the bond's pretty low on this case.
Understood, Judge.
Okay, because he has 2 separate incidences.
Understood,
Okay,
Judge.
thank you. Thomas Wilson. You're charged, sir, with battery. You have a capias. Bond is set in the amount of $1,000. You need to post a $1,000 bond.
Thank you, Judge.
Thank you. Harley Walker.
Yes, Judge.
Mr. Walker, you're charged with robbery by sudden snatching and domestic battery. I find probable cause on both counts. Bond is set in the amount of $3,000 on count 1, $1,000 on count 2. There'll be no contact with the alleged victim. If you have any firearms, you will surrender them to the local law enforcement agency. Omar Vera.
Thank you, Judge.
Mr. Vera, you're charged with domestic battery, $1,000 bond, tampering with proceedings, $500 bond, find probable cause. You got bond in the amount of $1,500.
If I may, Your Honor, the victim is going to be here. She's been in touch with the victim. She just, perfect.
Okay. Ma'am, will you raise your right hand? Swear to tell the truth, the whole truth, nothing but the truth, so help you God. Okay. Ma'am, do me a favor. Step a little bit to the side so I can see you. Okay. What do you want to tell me?
Judge, we're unable to hear.
Okay. Judge, she speaks very softly. Okay.
wanted
She
to-
has stated that Omar is not a bad person. He's not a violent person. Okay?
He's never done anything.
What are you
like-
asking me to do, ma'am?
I'm just asking for him to be released because, like I said, this has not happened before. He's going to school. He's not a bad person. That's all I have to say. He is a really good person, and this was just a simple misunderstanding.
Okay,
and I've
state.
already.
Yes.
Are you in danger for your life? I know you just asked for him to be released.
No, I'm not in danger. Like I said, he's not a angry person. Like, he hasn't done anything like this before. Like I said, it was just a simple misunderstanding.
And Judge, we'd be asking for ROR or PTR.
There are, but they weren't there during the incident. It was just a domestic dispute. I just told the officer that I just wanted to file a complaint, not press any charges. But then they wanted to just take him anyway.
Okay, this time the court will release Mr. Vera on pretrial, and he just report once a week by phone. Okay? And I'm not going to put a no contact order in at this time.
Contact is permitted.
Contact is permitted. Henry Estrada Martinez.
Spanish interpreter, please, Judge.
You're charged with, oh, okay.
Yes, Janice.
Okay, I know you're right there.
Yes, Janice.
You're charged, Mr. Henry Estrada Martinez, with battery on a pregnant woman. Bond is set in the amount of $2,000. I find probable cause. There'll be no contact with the alleged victim.
Señor Estrada, lo acusan de agresión física agravada. La supuesta víctima estaba embarazada. El señor juez encuentra motivo fundado para detenerlo, le impone una fianza de $2,000. No debe tener contacto ni comunicación con la supuesta víctima.
And if the defendant has any firearms, they will be surrendered to the local police agency.
Si el acusado tiene, I'm sorry, counsel. Si el acusado, señor, si usted tiene en su posesión armas de fuego, debe entregarlas al departamento de policía local.
¿Tienes preguntas?
Devontae McDermott.
Gracias.
Mr. McDermott, you're charged with aggravated battery, domestic. I find probable cause. Bond is set in the amount of $2,000.
Judge, I'd like to bring up, this was mutual combat with Dominique Brown, who's on page 2 of your Honor's docket.
I know. I know. The whole battle.
Okay.
$2,000.
Thank you, Judge.
Have a good day. That's why it's only $2,000.
Understood, Judge. Thank you.
No victim contact. Sorry. Thank you, counsel.
Photo orders of the injuries.
Photo order granted. Delon McLaughlin.
Yes, Judge.
You've got a out-of-state hold, no bond. You'll be detained going before the extradition judge, at which time your rights will be explained to you as to extradition to the other, I guess it's, excuse me, it's not state, it's county. It's Cherokee County, I'm sorry. You'll be detained till Cherokee County comes pick you up. Okay, Sarah Richings.
No problem, Judge.
Ms. Richings, you're charged. You've got a warrant for disorderly conduct. Find probable cause. Bond set in the amount of $100. Do you want to plead no contest?
Yes.
Okay, raise your right hand, ma'am. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Do you understand, ma'am? You have a right to have an attorney. At all times during the course of the proceedings, if you cannot afford an attorney, attorney be appointed to represent you. Put your hand up.
Yes.
Do you understand you have a right to go to trial, make the state prove the case against you beyond to the exclusion of every reasonable doubt? And you have a right to cross-examine all the witnesses, call witnesses of your own, put on a defense, and that if you enter a plea, you're waiving all of those rights. If you're not a citizen of the United States, this could be used in a deportation proceeding, but that does not apply to a citizen. Knowing that and understanding all your rights, do you wish to plead no contest?
Yes.
Time served, waive. Okay. Lisa Finelli.
Medical reset, Your Honor.
Georgiana Wilson. Paul Ryan. Thank you. Miss Wilson,
Yes.
you've got a possession of cannabis and a violation of probation. On the violation of probation, because of the violation of probation, I can't take a plea. All right? Because if you pled to the cannabis, that would automatically revoke your probation.
We're just asking to leave it in place, Your Honor.
Huh?
We're just asking for everything to be left in place.
Okay. And bond is set in the amount of $100 and $2,500. Ma'am, you'll be detained going before, unless you bond out, before Judge Levy. Thank you very much. Okay. Lorianne Creasman.
No problem, sir.
Ms. Creasman, you're charged with disorderly conduct. Find probable cause. Bond is set in the amount of $25. Do you want to plead no contest?
Yes, Your Honor.
Okay. Time served, waive. Have a good day.
Thank you.
Paula Radko.
Medical reset, that was Mr. Shakes. That was the MO Mr. Shakes was in for.
Okay. We don't, okay, no problem. Thank you. Whoops, sorry. Samantha Hester.
That's me.
You're charged with soliciting for prostitution. Find probable cause. Bond is set in the amount of $100. You want to plead no contest?
Yes, sir.
Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God. You understand, ma'am? You have a right to have an attorney, have the state, and if you cannot afford an attorney, be appointed to represent you. You have a right when you go to trial. You have a right to make the state prove the case against you beyond and to the exclusion of every reasonable doubt. You have a right to call witnesses and put on a defense. That by entering a plea, be waiving all of those rights. If you're not a citizen of the United States, this could be used to deport you, but that doesn't apply to a citizen. Knowing that and understanding, you want to plead no contest?
Yes, sir.
Okay. Withhold, waive. Toniana Della Rosa.
Judge, main jail, Ms. Della Rosa is on medical loan.
She's on.
What happened?
She's on reset.
Yes, Judge.
How do you know? Time served, what he said?
And North Broward seems to still have their microphone on.
Okay. Okay. Warwick Alexandria Warros.
Judge, we're on Stacy Downs. Ms. Downs.
What about Warwick? W-A-R-I-C-H.
She's a medical reset, Your Honor.
Okay. Stacy Downs.
Yes, Judge, main jail.
Okay, we've got a battery on a law enforcement officer resisting without violence and municipal ordinance violation. I find probable cause.
I'm sorry, Your Honor. Ms. Downs has indicated to me that she has no priors. This is her first brush with the law, and she can afford a $100 bond.
Well, $100 bond's not gonna cut it, counsel, but it appears that, Ms. Downs was under the influence of something. So the court at this time, since Ms. Downs cannot post bond, the court will release her to pretrial, and a condition of pretrial if she undergo alcohol and drug screening and any treatment.
Understood. Thank you, Judge.
So you want an evaluation also?
Excuse me?
For the treatment, she'll require to have an evaluation, so you want her to have an evaluation?
Yes, yes, yes.
Thank you, Your Honor.
And I'm asking for a photo order. She had a bruise on her face.
What's that?
I'm asking for a photo order.
Photo? Granted. Martiz Rodriguez. Ma'am, you're charged with possession of ecstasy, bond is set in the amount of $1,000. You also have a capias for a municipal ordinance, which is possession of paraphernalia. You want to plead out the municipal ordinance, and then you can just deal with the felony?
Yes, Judge.
Huh?
Yes, Judge.
Okay, ma'am, you want to plead no contest to paraphernalia?
Yes.
And ma'am, do you understand that may increase your points on the felony?
Okay.
Okay. And that is in the municipal ordinance. Court at this time. Time served. Have a good day.
Thank you, Judge.
Zaire Cordero.
No problem, John.
Ms. Cordero, you're charged with grand theft. I find probable cause, bond set in the amount of $1,000.
Conviction in case number 18006-024-CF10A, grand theft, possession of alprazolam, and resist an officer without violence. At this time, we're requesting a revocation of supervision.
Ms. Cordero, it seems you have a repetitive problem here. They advised me that you were on pretrial. I was ready just to put you on pretrial, but they don't want you. So the court is going to, I'm going to leave bond at the amount of $1,000 on this one. On the grand theft, the court is count one. The court is setting bond the amount of $1,000. On the possession, $1,000, and $500 on the resisting. Thank you very much.
Your Honor,
Yes.
that's prior to this occurring.
That's what happens when you go out on pretrial and then you get arrested again. Have a good day.
But I'm a little confused, sir.
Ma'am, you were arrested for 3 separate charges. You were placed on pretrial release. Now you were out and you've been arrested on a new charge. Pretrial release has surrendered you. Now, I have just set bonds in all counts, both cases.
So what would the bond be for me to get out?
Bond for you to get out would be about $3,500. Have a good day. Brittany Wilbur.
Judge, Ms. Wilbur is on medical loan.
Okay. Elena Marini.
Judge, Ms. Marini has been released.
Okay, thank you. Alyssa Hill.
No problem, John. Y'all ready there?
Ms. Hill, you're charged with 2 counts. Both of them are felony violations of probation. There are no bond holds. You'll be detained going before Judge Shearer.
All right.
I'm aware of that, thank you.
Thank you. Frankie Hancock.
No problem.
Ms. Hancock, you're charged with possession of cocaine. $1,000 bond. Find probable cause.
Your Honor, I would ask, I spoke to Ms. Hancock this morning. She's unable to post any monetary bond. She has a husband. He cannot help her post a bond either. This is a possession of cocaine. It's the only charge. What's going to happen is if you keep $1,000 in place in 33 days, she's going to get ROR'd because it takes so long for the state to test it. I would just ask Your Honor if you would put her on pretrial today, and she would have to check in tomorrow by noon.
She was on pretrial? But she doesn't have an outstanding bond or capias on that. She's on probation?
No, sir.
Okay. I'll send her to pretrial. Ma'am, I'm sending you to pretrial. You don't show up, you're going to sit in jail. Have a good day.
I'm sorry, I didn't understand what you said.
I'll tell you.
Okay.
Pretrial.
Thank you, sir.
You're welcome. Bianca Bailey.
No problem, John.
Bianca Bailey, you've got a violation of probation felony, no bond hold. You'll be detained going before Judge Fine. Amy Butler.
Medical reset, sir.
Reset? Okay.
Yes.
Christopher Wilberg. Mr. Wilberg, you got a trespassing municipal ordinance. Municipal ordinance charge. Do you want to plead no contest?
Yes, Judge.
You're pleading no contest? Time served.
Cool. Thank you, Judge.
Jerry Burgess. Mr. Burgess, you've got you got a capias for possession of cannabis, and you've got a violation of probation, and the numbers look the same. I don't know how they did that.
It could have just been on each charge separately. That happens sometimes.
Okay.
That it's 2 counts, but 1 case.
No, but what I'm trying to say is he's on probation for possession, and the possession charge is capias done also. But anyway, you'll be detained going before whoever the judge is on that case. Have a good day. Nasta Excellius. Okay, you're charged with possession of cannabis, no bond required, possession of drug paraphernalia, no bond required, DUI, $500 bond, DUI accompanied by a person under 18, $1,000 bond, unlawful speed, no bond required. You need $1,500 in bond. The court finds probable cause. Have a good day.
Thank you, Judge.
Greg Dickerson. Mr. Dickerson, you're charged with trespassing. It's a capias $1,000, find probable cause. Do you want to plead no contest? Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God. Sir, do you understand you have an absolute right to have an attorney at all times during the course of the proceeding? If you could not afford an attorney be appointed to represent you.
Yes.
Do you understand you have a right to go to trial, make the state prove the case against you beyond and to the exclusion of every reasonable doubt? You have a right when you go to trial to cross-examine all the witnesses, call witnesses of your own, and put on a defense that by entering this plea, you'd be waiving those rights. If you're not a citizen of the United States, this could be used in a deportation proceeding. Do you understand that?
Yes.
Knowing that and understanding, you want to plead no contest? Court accepts a no contest plea. Time served. Kevin Lucas.
Medical reset, John.
You got to be kidding me. Okay. Reset. Dudley Brown.
No problem. Right here, sir. Right here.
Mr. Brown, you're charged with a municipal ordinance violation. Do you want to plead no contest?
I don't know what that means, Your Honor.
Well, that means I don't admit I did anything wrong. I don't deny it. And I'll let you, Judge, use it the same as a guilty plea and dispose of your case today.
You could charge me with it, Judge, and then hopefully I won't keep the charges later on in the future. You could charge me. You could charge me.
Sir,
I'll keep the charges.
Sir, you're charged with a municipal ordinance of soliciting or panhandling. Do you want to plead no contest, or do you want to, you've got a $250 bond. You would need to pay a $250 bond to get out. If you want to plead no contest, if this is all that's holding you, you're out of there today.
Okay, I'll plead no contest, sir.
Time served. Have a good day.
Okay.
Jared Green.
Main jail judge.
Mr. Green, you're charged with open container. You want to plead no contest?
Yeah.
Time served. Have a good day. Kevin Byrne. Okay, thank you. Scott, James Scott.
Main jail judge.
Sir, you're charged with a municipal ordinance violation, $25 bond, fine, probable cause. Do you wish to plead no contest?
Do you? Yes, he'd like to plead no contest, Judge.
Okay, the court accepts a no contest plea. Time served, no return to that property. Have a good day. Angel Marty. Mr. Marty, you're charged with trespassing, capious, $500 bond. Do you want to plead no contest?
Yes, Your Honor.
Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Do you understand, sir? You have a right to have an attorney at all times during the course of the proceeding. If you could not afford an attorney be appointed to represent you.
Yes, sir.
You have a right when you go to trial to cross-examine all the witnesses, call witnesses of your own, and put on a defense. State has the burden of proving your guilt beyond the exclusion of every reasonable doubt. And by entering a plea, you'd be waiving those rights. Do you understand, sir, if you're not a citizen of the United States, that if you could be deported for this, but that warning doesn't apply to a citizen. knowing that and understanding your rights, do you want to plead no contest?
Sir.
Time served. Have a good day, sir. Daniel Rodriguez. Mr. Rodriguez, you have a driver with a suspended driver's license. There's a capias, $500. This is out of the satellite court. I'm not going to offer you a plea because this could habitualize you or cause other problems, but I will ROR you, but I'm going to warn you, if you don't show up, you got a whole bunch of problems. You understand what I'm saying? You got to get this squared away. Have a good day, sir. Tyrone J. Mr. J, you're charged with a municipal ordinance violation. Bond is set in the amount of $25. Do you want to plead no contest?
Yes, sir, Your Honor.
Time served, no return to the premises. Okay. Gary Altman.
Mr. Altman is approaching, Judge.
Yes. Mr. Alton, you have a is this a municipal ordinance or a state statute? Okay. You have a trespassing. I find probable cause. Bond is set in the amount of $25. You want to plead no contest? Raise your right hand, sir. Swear to tell the truth, the whole truth, nothing but the truth, so help you God. Sir, do you understand you have a right to have an attorney? If you cannot afford an attorney be appointed to represent you. You have a right to go to trial to make the state prove the case against you beyond the exclusion of every reasonable doubt. You have a right to cross-examine all the witnesses, call witness your own, put on a defense that by entering a plea, you're waiving those rights. If you're not a citizen of the United States, you could be deported for this, but that doesn't apply to a citizen. Do you want to plead no contest?
Yes, sir.
Time served. Have a good day. No return to that property.
Thank you, Judge.
Michael Phillips.
Judge, Mr. Phillips bonded.
Maurice Rowland.
Hello, hi.
He's what? Paul Ryan. Are you Maurice Rowland?
Yes, I am.
Mr. Rowland, you've got a misdemeanor, capias, $500, charges resisting without violence. Do you want to plead no contest?
Actually, Your Honor, I spoke to Mr. Rowland this morning. He has a couple of open cases. He's going to be held regardless, so my advice to him was not to plead today.
Okay.
What I would ask Your Honor to do, he's sitting in custody.
I just didn't want to get to the other courtroom, and when they want to release me, they jam me up for this, and I have to see.
What I was going to ask Your Honor for Mr. Rowland, he's being held on $7,501 bond. They count one $7,500. I believe it was Judge Malika who said count two at $1. I'm asking Your Honor if you would say count three at $1. He's unable to afford the $7,500. It doesn't matter if we would ROR him. He's going to stay in custody on the $7,500 bond. But if he does clear that up, he can post the $2 on the other two counts. I would ask Your Honor if you would just set it at $1.
But even if I post the $2, I still don't have anybody to sign for me and bond me out. So none of it makes sense. Because I'll still be stuck here because nobody can sign for me. The bondsman needs people on the outside to sign for you. So I'll be jammed up on $1 looking like a fool. And that's what I don't want.
Counsel?
And I also paid $500 cash bond that I didn't get the money back.
I understand. We know you're being held on.
So why am I here?
You're being held on the other count at $7,500.
$500. It's a $500 bond on that one. Have a good day. Maurice Miller.
Main jail, Judge.
Mr. Miller, you're charged with petty theft, $25 bond, violation of community or probation of felony, no bond hold, violation of probation, a felony, no bond hold. Sir, you've got the $25 bond on the petty theft, but it's no bond holds on the other two. You'll be detained going before the judge who placed you on felony probation. Have a good day, sir. Lionel Beaumont, I'm sorry. You're charged with driving while license suspended, and then you've got a capias on a felony, no bond. You got a violation of probation, no bond, and a violation of probation, no bond. $100 on the driver's license. You'll be detained going before the judge who, Judge Porth. Oh, Judge Porth, regular division or is? Okay. On the, I will ROR him on the suspended driver's license. You'll be detained going before Judge Porth. Okay, sir?
Yes, sir.
Okay.
Thank you, Judge.
Have a good day, sir. James Francois. Mr. Francois, you're charged with burglary of a conveyance. I find probable cause. State, no one, what do you want to do bond-wise?
Your Honor, we would be asking for $2,000, Your Honor. The defendant does have priors, 2017, possession of cannabis, trespass, 2015, expired DL, 2013, possession of cannabis, driving license suspended, he has from 2008, battery on a law enforcement officer.
Okay. So how much bond are you asking for?
Judge, we would ask for $1,000. That is something that Mr. Francois would be able to afford. $2,000 would be something that he was unable to afford.
$1,500 bond. Have a good day. Yvel Magalori.
Yes, Judge. Yes.
Okay, Mr. Magalori, you have a fleeing, no bond required, reckless driving, $100 bond, possession of cannabis, $100 bond, leaving the scene of an accident, $100 bond, resisting an officer without violence, $100 bond, unlawful speed, no bond required. Unlawful possession of the ID of another $1,000 bond. You have a felony capias, no bond. You have count 9, felony capias, no bond. Count 10, felony capias, no bond. Count 11, felony capias, no bond. And you have a violation of probation, felony, no bond. You'll be detained going before the felony judge. Have a good day, sir.
Thank you, Judge.
What's that?
On the fleeing, the bond needs to be set on that count.
Which one is that?
The first count.
Oh, I thought the no bond was required.
Yeah, no, that's a whole magistrate.
Okay. $500 bond. Yes, what?
An assault from 2016.
Yeah, but counsel, he's got like 5, no bond.
Okay. What did you say, Your Honor? 1,000? 500.
500. Where's he going? Xavier Burton.
Yes, Judge.
You're charged with possession of fentanyl, riding a bike without a light, probation 2-count probation violation. Count 1 is $1,000 bond. Counts 3 and 4 are no bond holds. You'll be detained going before Judge Merrigan. Vivek Patel.
Yes, Mr. Patel is present.
You're charged, sir, with driving under the influence, $500 bond, fleeing, $1,000 bond, exceeding the state limit, $1,000 bond, and with more than a third violation. Then disobeying a red light, you have a total of $2,500 in bonds.
Judd, I'd ask Your Honor to consider reducing it to $1,500. Mr. Patel is a grad student, has very little money, and that is something he could afford and get back to class and continue in school.
I'm going to leave it the way it is, counsel.
Understood, Judge. Thank you.
Diego Lopez. Mr. Lopez, you're charged with possession of heroin, find probable cause, bond is set in the amount of $1,000.
Thank you, Judge.
Okay. Zachary Phillips. Okay, Mr. Phillips, you're charged with resisting without violence, $100 bond, trespassing, no bond required. You have a $15,000 felony hold, and you have an out-of-state hold, no bond. The out-of-county hold is from Dade. The out-of-state is from Alabama. So you are facing being sent to Dade County. Then once you clear the one in Dade County, you will be facing extradition to Alabama. I don't know if any of these are violations of probation, but if you want to plead no contest to the two misdemeanors, we will dispose of them, and then you will be transferred to Dade County and then face extradition to Alabama.
Yes, sir. No contest.
Raise your right hand, sir.
Judge,
okay.
He's doing his best.
You're fine. Do you understand you have a, okay, swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Do you understand, sir, you have a right to have an attorney at all times during the course of these proceedings? If you cannot afford an attorney be appointed to represent you?
Yes, sir.
Do you understand you have a right when you go to trial to cross-examine all the witnesses, call witnesses, make the state prove the case against you beyond and to the exclusion of every reasonable doubt, that by entering this plea you'd be waiving those rights?
Yes, sir.
Do you understand that if you're not a citizen of the United States, these are criminal charges and they could be used to deport you? But that warning does not apply to a citizen. You understand?
Yes, sir.
Court at this time accepts the no contest plea to counts 1 and 2. The court sentences him to time served, waives court costs. He may be transferred forthwith to Dade County. Have a good day, sir. Terrence McKay. Mr. McKay, you're charged with petty theft. No bond required. Petty theft, no bond required. Driving with a suspended driver's license, a third time, which amounts to a felony if provable, a $750 bond, and then you have failed to register motor vehicle and another petty theft. Court at this time finds probable cause. Bond is set in the amount of $750, but I will send Mr. McKay to pretrial.
Thank you, Judge.
Anthony Banks.
No problem, Your Honor.
Mr. Banks, you got a violation of parole. No bond. You'll be detained going before the parole board.
Okay.
Anthony Bryant.
Yes, Judge, main jail.
Mr. Bryant, you're charged with grand theft auto. Bond is set in the amount of $1,000. I find probable cause. Any priors? Elsie, you're talking to the table again.
Driving while license suspended, 2014 driving while license revoked.
Any felonies?
Yes, Your Honor.
He has 3 pending cases. Okay. Never. $1,000 bond. Have a good day.
Judge?
Yes.
Excuse me, Judge? Mr. Bryant would like the court to order SAP, the Substance Abuse Program, for him to complete while he is in custody.
So ordered.
Thank you, Judge.
Sheldon Gray. You're charged with robbery of a firearm, aggravated battery with a deadly weapon. There is a no bond hold on count 1, and there is a $50,000 bond on count 2. I find probable cause all counts.
Your Honor, does Your Honor find proof evidence presumption great on count 1? Due to the punishable by late felony?
I don't have anything. I don't have anything except for the warrants, and the warrants were issued by Judge DeLuca, and he set a no bond hold on count 1.
Right, but the finding needs to be that there's proof evidence presumption great.
Fine. How do I do that?
Excuse me, Judge. I'm having trouble hearing the state. If they could maybe speak in the microphone a little better, please.
Because Your Honor found probable cause, Your Honor's, the finding needs to be proof evident presumption great. And since Your Honor.
No, counsel. I have to have some facts with which to do it with, and I have been provided none. And actually.
Oh, you don't have the facts. Okay, I can give a recitation of the facts, Your Honor. On August.
But a reviewing judge has already issued a no bond warrant.
Correct, which is.
Right.
Fine.
It's a no bond hold for magistrate for him to be continued to be held no bond.
Well, that's not the way I read it. This is an arrest warrant executed by a judge based upon a probable cause affidavit.
If you give me a sec, I'll give you a case on point. When it comes through magistrate, he's never magistrated on the case before. So a judge cannot preclude bond at magistrate. What a judge can do is preclude a convenience bond being set. The convenience bond set on for behalf of the defendant. So he was being held no bond because there was no convenience bond. But at magistrate, to be continued to be held no bond, either the state needs to file for pretrial detention or Your Honor needs to make a finding.
State, you have anything?
I can just lay out the facts, Your Honor. But on August 7, 2018,
No, I don't have. Okay. If I have to set bond, I'm setting bond in the amount of.
No, there shouldn't be bond set. That's
$50,000 on count 1.
If bond's supposed to be addressed, Your Honor, then that's something that needs to be done at a later time in front of the judge whose case this is in.
And at this time, what the state is asking, Your Honor, is a continued no bond hold. The initial one, as counsel explained, was only so that we can get to this point.
Well, I thought please, my understanding is, if this is done by a warrant issued by a prior judge, it's a good no bond hold. I don't have to find presumption evident. And okay, it's a no bond on 1. It's $50,000 on 2. If I'm wrong, somebody.
No, Judge.
Fine. I made my ruling, counsel.
Judge, I have to strenuously object.
Then fine. You can object. You can find. You can. I can be corrected. Okay.
Justice delayed is no justice at all, Judge. It's a Supreme Court
Counsel,
aborted case.
Counsel, if you wish to get a writ, please do.
I would like to lay my record.
Leverton,
Your Honor,
Harrington.
Your Honor, you denied me the record. I would like to lay a record.
Counsel, you've made your record.
I would like to cite the case on point.
Fine, give me the case right now.
It's 768 Southern 2nd, 1070. That is State versus Norris. It's a Supreme Court of Florida case.
Okay, that's fine. Thank you, counsel.
A judge cannot
Counsel, thank you.
preclude.
Leverton Harrington.
Yes, Judge.
Okay, you've got possession of cannabis and a traffic violation and a felony warrant for violation of probation, which is a no bond hold. Count one is a $100 bond. Yes, ma'am, who are you?
I'm his mother.
Okay, ma'am. He has a no bond hold for a violation of probation. On the possession of cannabis, I will ROR him but it doesn't change. He still has the no bond hold.
Okay.
He'll just be able to get out once he deals with the no bond hold.
All right, thank you.
Thank you. Eddie Edwin.
Yes, Judge, Mr. Ed, my left.
You're charged with driving while license suspended and a probation violation. $100 bond on count one. A violation of probation is a no bond hold. I will ROR him on the count one. Count two, no bond hold, he'd be detained going before, I believe that's out of Brevard County. So he can be transferred up to Brevard.
Thank you, Judge.
James Nice.
Mr. Nice is present to let Your Honor know in advance. Mr. Nice has absolutely zero money and cannot afford even a $25 bond.
Possession of heroin, $1,000 bond. Possession of paraphernalia, no bond required. What are his priors?
2009, driving while license suspended. 2006, possession of cocaine. 2005, trespass. 1995, DUI. And in 1996.
I'll release him to pretrial release with a drug evaluation and treatment.
Thank you, Judge.
There you go. Daniel Brockington. What's the one on the robbery that we did 3 times ago? Excuse me? Yes. Let me put that on Gary, Sheldon Gary, in the jail. Don't let Sheldon Gary get away. I put it on recall. Daniel Brockington, you're charged with petty theft, $100 bond.
Medical reset, Your Honor.
Okay, reset on him. Okay. Christopher Nordurst.
Durft is present.
You're charged with carrying concealed firearm, $1,000 bond. State priors.
2012, no registration, unlawful tag, sticker attached. State charges, two counts of each, Your Honor. That's
What? I didn't hear you.
2 counts of both from 2012. No vehicle registration, unlawful license tag, sticker attached.
That's it? Okay.
Judge, I'd ask for ROR.
Pretrial release.
Yes, Judge.
What's that? Oh, his bond's been posted. You're in better luck.
Okay, fantastic. Thank you, Judge.
Found probable cause. Robert Flanagan. All right, he's bonded.
Judge, Mr. Flanagan is present. I'd like to let the court know that he's a disabled veteran. He served in Afghanistan for over a year as a specialist.
Who do we have?
Robert Flanagan, Judge.
Has his bond been posted? His bond's been posted, sir.
Fantastic. Thank you.
Thank you. Joseph, N.L. Joseph.
Judge, Mr. Joseph, also bonded.
Okay, thank you. Alexander Gale.
Hello. Yes, Judge.
Okay, aggravated assault with a deadly weapon without intent. Court finds probable cause. State, any priors?
Your Honor, we just see that there's a pending case. We didn't see any priors when we did the look.
Okay.
2018 possession of cannabis pending right now.
Bond is set in the amount of $3,000. No contact with the alleged victim. Roy Mason. Sir, you're charged with burglary, with an assault or battery, no bond hold, and aggravated battery with a deadly weapon, $7,500 bond.
Judge, Mr. Mason indicated that his girlfriend indicated to the state that she would be waiving prosecution.
Well, that's nice of him to tell us, but that doesn't mean anything. Okay. State, what say you on bond on count one?
Your Honor, the state will be requesting a no bond hold. This is a punishable by life felony. And according to Isasa v. State, the case that we have referenced earlier, a 2017 case, the court has to find at this stage a determination whether the proof in front of Your Honor shows that it's evident or the presumption is correct.
Your Honor, I do not believe this rises to proof evident presumption grade. That goes beyond a reasonable doubt. Using the language of the statute, I have to read off my phone how to get a copy from the state. I did not get a paper copy. But when Mr. Mason allegedly re-entered the apartment, that the door was opened by Miss Davis, and Miss Davis, according to PC, we're not sure who made that statement, believe it was another person, but it doesn't say that actually Mr. Mason was not allowed back in. It just says that Miss Davis opened the door thinking it was someone else, and Mr. Mason entered. It did not say that Miss Davis or any other occupant in the house or apartment.
What about when he kicked the bedroom door down?
But that's when he was actually invited into the house. That was there were two separate incidents. There was one when he was invited in.
Well, opening the door is not an invitation in. Opening the door may be identifying the person who was outside. He then entered, then kicked in the bedroom door. Go ahead. I'll let you go.
The kicking of the bedroom door happened before that incident. What happened is, according to what we have before us, he was invited into the house. There was some sort of argument in the house. He kicked open a bedroom door. There was no one in the bedroom. According to the affidavit, he kicked open the bedroom door to retrieve a shotgun. There was no one in the bedroom at the time.
According to the affidavit on the warrant, he kicked open the door of the bedroom, got the shotgun, loaded a shell in it, and pointed it at the person. Well, that's kind of like,
I'm not objecting to count two. What I'm objecting to is specifically when it comes to count one as it being a burglary. After that point, he left the apartment. He knocks on the door is open. We have nothing to say he was told he was not allowed to enter. There's nothing to say that he was stopped from entering. He entered after the door was open. What the state's asking Your Honor to find today is proof evident presumption grade that actually goes beyond a reasonable doubt. This does not preclude them at trial when they have witnesses, when they have live testimony, if they have surveillance. They might be able to meet that burden, but as of right now, all we have is this affidavit, and it is completely silent to if he was actually invited in or if he was told no. That being that we just don't know, I don't believe Your Honor could find proof under presumption great.
Your Honor, it literally says, and she opened the door, at which time the defendant forcefully pushed his way inside of the residence without permission. So, counsel, I don't know why he did it, if he didn't see that part, but that literally goes, Your Honor, to the fact that
That
he
does not
didn't
say
have
he was
permission.
not given permission.
It says forcefully inside the residence without permission. Without permission.
She did not, but there does not say that anyone told him he's not allowed to come in. If a door is open, you can potentially read that as someone inviting you in. It does not say anyone told him he cannot enter or that he should not enter. I agree, you might be able to convince jurors of that, but that is not today. You do not have any live testimony to that.
But does it not say that he was forcibly pushed his way in?
It says that. It says exactly that. And we know he did it without permission because it says it was done without permission.
Does it not?
It's just because someone does not give permission does not mean it cannot be read as permission. A door was open for him, and we have nothing to say. Anyone said, "Do not enter. You're not allowed in."
Counsel,
in that apartment.
if you have to forcefully push to get in, doesn't that indicate that you don't have permission?
The problem is we have no idea who said that. If they were under oath, we don't know which witness, what victim, anybody who said it. As far as we know, that's what the officer's saying. It is unclear. We have no live testimony. There are questions, legitimate questions as to the facts here. What the state's asking is Your Honor to make a finding actually beyond a reasonable doubt. I don't think they can meet the burden of beyond a reasonable doubt today. That does not mean they can't potentially do it in the future. But based on this, I do not think it's that clear.
Okay. Court finds that proof is evident, presumption is great, no bond. Okay. Yanel Walker. Mr. Walker, you're charged with possession of cannabis, a felony amount.
Judge, Mr. Walker would actually request you leave the bond as is. He's having some family members trying to post it who may be doing it right now, and we don't want to disrupt that process.
Got it. $1,000 bond, find probable cause.
Thank you, Judge.
Okay. Justin Jones. You're charged, sir, with possession of cannabis, $100 bond, driving while a suspended driver's license, no bond required, expired tag, no bond required. Then you have counts 4 and 5, violations of felony probation, no bond on each count. You'll be detained going before the judge on the felonies, which is Judge Sigel. On the cannabis, the court will ROR him on count 1. So once he disposes of the felonies, violations of probation, he can be released. Darnell Sears. Mr. Sears, you're charged with violation of probation. It's a no bond hold. You'll be detained going before the judge to whom the case is assigned. Have a good day, sir. Ralph Drain.
Judge, Mr. Drain is present. His mom is going to be posting his bond. His mom has very, very little funds. She'd be spending whatever discretionary income she has on his bond.
What's his priors?
Your Honor, he currently has a pending felony, fleeing and eluding, reckless driving, and no registration. So the fleeing and eluding is the felony. 2017, I see a no valid driver's license. 2016, resisting without violence. 2015, trespass, and 2014, battery.
Right.
And that pending case is from just 2 months ago.
Judge, of course, if PTR is possible, that would be.
Police cars?
Just doing my job, Your Honor.
Count 1 is 1,000. Count 2 is 1,000. Count 3 is 100. Have a good day. Jermaine Watson.
Yes, sir, Mr. Watson.
Mr. Watson, you're charged with resisting a police officer without violence and fleeing in disregard of the safety of persons and property and operating without a valid driver's license, leaving the scene, no tag. Court sets bond on count 1 the amount of $100. Court sets bond on the count 2 in the amount of $1,000. And have a good day, sir. Find probable cause, all counts. McFadden. Mr. McFadden, you're charged with grand theft auto, $1,000 bond, operating without a valid driver's license. State, what is his priors?
Your Honor, he currently has a pending felony of throwing a deadly missile, and his priors are juvenile priors.
Okay. All right, the court will pre-trial release.
Thank you, Judge.
Thank you. Paul Williams.
That was overstate's objection for the record, Your Honor.
Mr. Williams, you're charged with possession of cannabis, $100 bond, violation of probation or community control, no bond. You'll be detained going before the judge on the violation of probation. On Wendy Pierre Lewis.
Mr. Williams was asking if he could plead to count 1.
It's a violation of his probation, counsel.
I've explained this to him several times. He keeps asking me.
I understand that, Your Honor.
Sir, do you understand that if you enter a plea to the misdemeanor charge, that will be an automatic revocation of your probation, allowing the judge in the criminal proceeding to sentence you to the maximum sentence under the law without anything other than the record of this proceeding?
I stand corrected, Your Honor.
Thank you, Judge, for helping.
Raise your right hand, sir. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
After hearing from counsel and from yourself, Mr. Williams no longer wishes to plea out that.
Oh, okay. All right. With Mr. Pierre Lewis.
Medical reset, Your Honor.
Thank you. Andrea Rett. Reset. Okay. Then Molina Pinto.
Medical reset, Your Honor.
Okay. And Presley Francois.
Medical reset.
Okay. I put Mr. Sheldon Gray on recall. Counsel, do you have that case?
I do, Your Honor. I don't have a copy. You have one more.
Yeah, the murder case.
We have
I don't want
to. We'll do that.
State, do you have a case that says I don't have to make a finding?
And just, what case is it, just so we're on the same case and it was on recall? That would be great, if we can turn to it.
Okay, the issue, and if I'm phrasing it in a way that you would prefer to rephrase it, the issue is Mr. Gray was arrested on a warrant issued by a Judge DeLuca on an affidavit, okay? And I don't have any of that other than the warrant itself.
The state has it. They could just give it to you to look at.
We offered, right, we have the affidavit and the warrant for your honor to read as well.
Oh, okay. Now, the question is, because Judge DeLuca issued the warrant, and he is and reviewed same, issued a no bond on 1 and entered a bond on 2, do I have to review and make a finding of the proof evident presumption great, or does Judge DeLuca's no bond stand on itself?
I believe the state and I are in agreement. What the case law is, if your honor is going to hold Mr. Sheldon or Mr. Gray beyond today, no bond, one of two things has to happen. Either the state has to make a filing for pretrial detention, or your honor needs to make a finding of proof evident presumption great. Otherwise, an arrest warrant is for probable cause, not proof evident presumption great.
I got you. Okay, if we both agree, I'm not going to fight with you.
Yes, Your Honor, the state does agree as to the fact that at this stage, Your Honor has to make that finding.
Can I have an affidavit or something, since I have not been provided? Because that's why I couldn't make a ruling.
The warrant is in the front and the affidavit is in the back, Your Honor.
Be right with you. Okay. State?
Yes, Your Honor.
You are seeking the court to make a finding of the proof evident presumption great.
Yes, Your Honor.
Tell me why.
Your Honor. Well, it's okay. It's robbery with firearm, Your Honor, which is one of the enumerated punishable by life felonies. Because of that, the finding does need to be proof, evident, presumption. Great. As you have already read the facts, there was a firearm involved at which the defendant tried to get the purse from the victim. And then during that, eventually shot the victim at his foot, which it seems like it penetrated the victim's foot. So even though that's the aggravated battery part, nevertheless, a firearm was used to try to steal.
To attempt the robbery.
Right.
Defense?
I know the state wants to say that what's before say is armed robbery, but actually the warrant itself, it's for attempted armed robbery. And because it's an attempt, according to the attempt statute, which is 777.04, I'll read from the statute, except as otherwise provided, and then they cite to 893, which is the drug chapter. If the offense attempted, solicited, or conspired to is a life felony or felony of the first degree, the offense of criminal attempt, criminal solicitation, or criminal conspiracy is a felony of the second degree. I agree armed robbery by itself would be a life, but this actually says attempt on it.
State? Okay, let me do this. The court at this time finds from the evidence that there's probable cause for the offense. The court finds from what has been able to be presented at this time that the proof is not evident and the presumption great as to justify the no bond hold. The court will set bond in the amount of $75,000.
Respectfully overstate the question.
So the bonds are set in the amount of $75,000 and $50,000.
That's my copy.
Oh, I'll give that back to you, counsel. Thank you very much. Okay. $75,000 on one, $50,000 on count two. We now have Richard Cunningham.
And there's no victim contact on that?
Yes. Mr. Cunningham, you're charged with premeditated murder. There is a no bond hold. Are you invoking his rights, counsel?
Yes, Judge, I am.
Granted. The court finds probable cause for the offense and for the no bond hold. Anything from the state?
Yes, Your Honor, this time we'll be asking the court make a finding of presumption grade as well as in this case, given it is punishable for life with felony as well.
Counsel?
To be blunt with the court, I think everyone has the same affidavit where there's a lot of information that's kind of scribbled out.
A little redacted?
A little redacted. It makes it hard. I understand why an officer might think that's the best, but I think it's also they can provide the court and everybody with the information so we can actually make an argument. It's hard to follow exactly who's who because we don't actually have it. The one thing that I would point out that is troubling, and again, I don't know if it's remedied or not based on who's who, but we have one victim who says they couldn't make an identification because the alleged people were wearing masks. We then have somebody else, I don't know the name, who says they were able to make an identification. So we do have this conflict going on. While Mr. Cunningham's before us today, I don't think it'd be improper if maybe the state asked for a reset for 24 hours so we could get an unredacted copy to make proper arguments, because I feel I'm a bit handicapped just because I don't know who's who here, and that there are those differences, that on page 3 we have a victim saying that we have people wearing masks, they can't make an identification. And then on page 7 and page 8 we have a different victim, excuse me, not a different witness, my mistake, different witness saying that they were shown photos and were able to make an identification, which then would mean the people weren't wearing masks. And so we have contradictory witnesses making contradictory findings. I don't know the relationship between the different witnesses.
I don't know if they are exactly contradictory. They're somewhat different.
Well, if one person can say they can make an identification, one person saying they can't because the people are wearing a mask, then I don't know how the second person can make an identification with a mask.
Because
how
it
can
is
you see?
quite
So I do
possible.
find
It is quite possible, but I won't speculate on the record what could have occurred. But they say they could make an identification.
Right, and Father Mariano, the surveillance video that shows the incident as well, the witnesses, and granted the names of the witnesses, some of those witnesses was blocked off, but it doesn't deny the fact that there is a positive identification, and of the video itself, that witness is able to watch the video and identify all of the individuals in there, and for purposes, the court and counsel has been informed as to why the reduction occurred. So based on the video surveillance and the fact that there are witnesses who make a positive identification, the state submits to the court that there is enough evidence to show that there's proof of guilt is evident and presumption free.
I understand why the redactions were made by the officer. I just think it's improper for us in court to have to try to piece together what's happened. I understand there was surveillance. I don't believe it's not mentioned that actually faces are seen in the surveillance, which again, I can't tell the difference between the different witnesses. All I know is I have one witness saying there were masks that were being worn and so they could not make any identification, and then one saying they could. I can't tell where else these people fit in and what their relationships are because we can't tell because they're redacted. I know some people say they've known these people allegedly for years, some people saying they don't.
Counsel, the court understands your point that it is not easy reading with the redacting, but the court feels upon close reading that the proof is evident and the presumption is great, and it will be a no bond on Mr. Cunningham. Thank you very much.
Thank you, Judge.
Thank you. I believe that concludes the docket. I want to thank all the attorneys and I want to thank the staff. Everybody's done a great job today. Really appreciate all your efforts. Thank you.
Thank you, Judge.
And I think I got a couple things to sign, and everybody have a good day.
Have a good weekend.
It's